John Adame and Melissa Baker. Is that you, Miss Yasmin?
Yes, ma'am.
Okay, you were previously sworn. The rent is 1013, is that right?
Correct.
And you just want July prorated at 980, is that correct?
Yes and no. Their lease contract expired on the 24th of this month of July.
Okay,
They're still current. Hold on.
uh-oh.
I'm sorry, somebody's here screaming. Um, oh, I think Bitia's here. Hold on. She's Bitia. Oh, no, no, no. We're not doing that. We're on court right now. Give me 1 second.
No, you are she already dismissed my case.
She did not dismiss your case. The reason
Okay, tiene que yo estuve esperando una pinche hora.
Okay.
Una pinche hora.
Give me a second.
Don't be fucking like that.
I was not. You were not on the phone.
I was on the fucking phone. Do you need fucking?
Okay. You have to give.
Aquí tome, aquí.
Okay. Do you want to go and log in? Because you're literally on live.
I can't fucking log in.
Okay.
I couldn't log in.
Pitia, you have to call. You have
Yo
to.
llamé una mira, aquí te voy a enseñar las llamadas.
Tell her to go try the phone number again, Miss.
Una pinche hora.
Do you hear the judge? Pitia, do you hear the judge?
Right here.
Miss Velasquez,
54 minutes. I was waiting.
I understand. We tried to
I
message you.
can't log in. They didn't give me the passcode. They gave me the fucking.
There's no passcode. You just need Can you try again and we'll let you in right away.
Don't dismiss. The what?
You're on live, by the way.
I know I'm on live.
Miss
And I've been 54 minutes. On this fucking case. 54 minutes. Almost an hour.
Can you try? Can you call again and we'll let you right in, okay?
They didn't give me the password. They gave me the passcode.
There's no password.
They didn't know.
Look, just dial right here. Look, dial this number.
Tell her to dial the number and we'll let her in.
There's no reason.
There's no
Mamacita,
reason.
mira, mi amor.
I
Mira,
understand.
55 minutes. That was
That's how
55 minutes. Like, really, look. For real. Que no me encajone. Que no me encajone. Oh,
I'm sorry.
Yo me calmé.
Hold on.
We have 3 more cases, right, Miss Yasmin?
I'm sorry, I can't hear you, Your Honor. It's just that I have her in the office and I cannot hear you. I'm sorry. We were going based on John Adame's case.
No,
and then
Right.
hold on. John Adame, actually their lease contract expired on the 24th of this month.
So
They
that
have
would
not
be $784.
correct.
Okay.
Which is their prorated amount plus this amount for the remaining of the month. They have not yet also paid the rents previous. Sorry, Your Honor. They have not paid a little bit of their June rent as well, so I'm trying to grant possession.
No. Go back to my case, and I'll speak to the judge. Porque a mí ni siquiera me dieron el pinche paso.
Yes, I want to get possession of this unit of John Adame and Melissa.
Okay, is there any left owing in June?
For the month of June, it's $213, Your Honor.
Okay. So it's 997 is
Correct.
what's owed. Okay.
Yes,
And the appeal bond is 2026.
correct.
Okay. So we've got Dexter versus Jonathan Rodriguez.
Yes, for Jonathan Rodriguez, he has not paid for the month of July, which is this month.
Right.
I just heard her and her
Lease contract expired July the 3rd of this month of this year.
Okay.
Their rent is $1,335, so I'm asking for $1,335 along with late fees and judge
I can just give you the background.
correct. Yes.
Fuck that shit.
Okay, so I need you to just have a seat and we're gonna go ahead and call
Okay,
him.
well, cuando yo estaba hablando, when I was talking, I was like, hello, can
Lydia.
you hear me? I was almost an hour. Aquí está, in the record. Almost an hour.
Yeah, you wanna take a seat?
You want to have a seat and then she can go ahead and give you a call? You can go ahead and.
No.
Okay,
Judge,
Lydia.
I think she
You're
was
gonna-
I think she was the phone number, and I called out to push star 6 times.
Before we even get into the chaos, you need to understand something. Eviction court is already one of the most emotionally charged courtrooms there is. People's housing, finances, and pride are all on the line at the same time. Add technology into the mix, and things can spiral fast. Today's first case is a perfect example of how a simple technical issue can explode into absolute mayhem when emotions take over. Hat starts as a routine eviction hearing quickly turns into something you almost never see, the plaintiff and defendant ending up in the same physical room during a live court session, arguing in real time, on the record, while the judge listens. This isn't reality TV, this is an actual courtroom where every word matters. Pay close attention to how the judge stays calm, how the plaintiff tries to keep things professional, and how the defendant completely loses control of the situation. Because once this goes off the rails, there's no rewinding it. And trust me, you're about to see exactly why judges hate remote hearings when people don't know how to be.
1722-241589, 241136, and then we have a felony file. This is 241796 FY appearances.
Morning, Your Honor. Jeffrey Fanto on behalf of Mr. Moore. As to the state cases, we've waived formal reading, asked for warrants to be recalled. As to the city case, that's set for pre-trial on the 5th, and request would waive formal reading and stand mute.
Okay, so as to 241796 FY, the felony case, this is a charge of home invasion, third, and domestic violence. Mr. Moore, you have the right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have the right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearings. In the event you can't afford an attorney, one will be appointed to represent you. You have 2 court dates within the next 21 days. Your first court date is your probable cause conference, which you can appear at via Zoom, and that is set for August 26th of 2024. Following that, on September 9th of 2024, you will have your preliminary examination. At that examination, the prosecutor will have to show that a crime was committed and probable cause exists to charge you with that crime. With respect to the remaining 3 cases, we have a state of Michigan versus Christopher Moore on 1136. State of Michigan versus Christopher Moore on 241589, and then we have a City of Taylor case 241.
Right here is where the tone quietly shifts. Up to this point, everything has been controlled: sponsor read, introduction, standard docket flow. But eviction court doesn't wait for anyone, and that's what we're about to see. When names are called and parties don't check in on time, judges don't assume malice, but they also don't pause the entire courtroom indefinitely. Notice how the court staff mentions the defendant didn't check in during the designated window. That detail matters. Courts run on schedules, not excuses. And when you're appearing remotely, the responsibility is entirely on you to be ready, muted correctly, logged in correctly, and paying attention. This case hasn't gone sideways yet, but the fuse has been lit. The judge is already moving forward, and the plaintiff is present, sworn in, and prepared. That imbalance alone puts the defendant at a disadvantage before she even speaks.
1722, and that's the B&E. As to all of those, the warrants have been set aside. They'll be set for pre-trials.
Judge, I would note that Moynihan is on. I would just ask that the 2 misdemeanor state cases be set for the 26th as well.
The misdemeanor state case be set for is the 26th, so that's a Monday?
That's the same day you set for the PCC.
Oh, okay, so we'll just have them all?
The same parties.
All right.
Then the state, or the city case, I think is September 5th, if I'm not mistaken.
Yeah, there's a date of September 5th on that one. And then Ms. Moynihan, all three of the felony matters, then when we come in for the arraignment, or I'm sorry, the probable cause conference on August 26th, we'll just have those two misdemeanor files follow the felony. Now, as to bond. Ms. Moynihan, is there anything you have to say as to bond?
Yes, Your Honor. Thank you. Tina Moynihan on behalf of the people, P84-692. Judge, we were in court on Monday. I was there as the prosecutor covering the docket for Ms. Sob and Ms. Davidova, and Mr. Moore was supposed to appear for an arraignment. He did appear by Zoom momentarily and then disappeared. He would not speak with Mr. Gizicki. With my understanding, Mr. Gizicki attempted to have conversations to proceed with the arraignment. And then Mr. Moore decided to log off before the case was ever called. My understanding, he then contacted the courthouse and spoke to a clerk downstairs and made.
This is a rare moment where the host pauses, and for good reason. What's happening here is actually very important procedurally. The judge didn't dismiss the case. She passed on it temporarily. That's a huge distinction. Passing means the court is willing to circle back if the defendant gets properly connected. Dismissal would have been a gift. The court is doing more than required here. Judges are not obligated to wait nearly an hour for someone to figure out how to unmute themselves. Yet the judge allows time, and the plaintiff even attempts to help facilitate the connection. That level of cooperation is unusual in eviction court, and here's the key warning sign: when opposing parties start communicating directly during a live hearing, things can go south instantly. There are rules for a reason. Once those lines blur, professionalism tends to disappear, and emotions take over.
In that incident, Judge, there has been a warrant requested. I am in the process of reviewing that this morning. The allegations there are that the defendant broke into the complainant's home again overnight, forced his way into the home. He then adjusted cameras throughout the home that the complainant had so that he could not be observed. He's seen wearing all black, a hoodie, as well as a mask covering a portion of his face. He then enters the complainant's bedroom. He pulls a gun from his pocket and then shows that to the complainant, claiming that her fingerprints were on that gun and putting her in fear of an altercation ensuing. Further from that, he's then seen leaving the location by the complainant and heading out in an unknown direction. My understanding is that he's been staying across the street at the home across the street from her residence. And I believe that that is also going to be considered a violation of his bond that's been issued, that he's had no contact with the complainant, that he's not returned to that residence. And then there's allegations of new criminal activity. In addition, Judge, to his failure to stay in court until the case was called on Monday, I do believe that Mr. Moore is a danger to the complainant as well as to the public as a whole. He shows a wholesome inability to comply with the court's orders. I would be asking for a $250,000 cash surety bond, no 10% with a GPS.
And there it is, the moment everything breaks. The phrase, "somebody's here screaming," should never be said in open court, and yet here we are. This is the exact scenario judges dread: one party attempting to comply with court procedure while the other is emotionally unraveling off camera. What makes this even worse is that this argument is happening live, asterisk on the record, and in front of the judge. Every interruption, every curse, every accusation is being heard by the person who decides possession of the property. There's no sidebar. There's no do-over. The defendant believes she's been dismissed. She hasn't. The plaintiff knows that. The judge knows that. And the louder this gets, the more credibility drains from the defendant's position. In
I guess we have allegations that I don't know that the court should take into consideration relative bond as these cases stand. However, I would note that Mr. Moore does have some serious medical issues. At least if we could mark the files medical so that Wayne County knows. He is on SSI.
Okay. I don't think there's, the things I'm to take into consideration is whether or not he's a danger to the community. He's a lengthy criminal history. His behavior in this court has been absolutely egregious. Since these cases have started, he has assaultive criminal convictions. He clearly does not have any issue ignoring court orders. He is certainly a danger to Miss Butcher as well as the community at large. He's certainly a flight risk. He was already in immediate warrant status on one of the domestic violence charges on August 5th when he failed to appear for court. We've had a separate case where he had an immediate bench warrant on two different dates, both June 13 and August 5th, for failing to appear at court. He's now got pending against one complaining witness, 2 domestic violence cases, 3 domestic violence cases, a B&E and a home invasion. There's an allegation that a firearm was used in one of those instances. There was a police report filed. Detectives had to come over to the court Monday after there were allegations that Mr. Moore called the court was extremely.
This is no longer a technical issue, this is a full emotional breakdown happening in real time. The profanity, the interruptions, the refusal to listen, all of it is compounding the damage. And here's the brutal truth, none of this helps her case. Not even a little. Judges don't expect perfection, but they do expect respect. When someone talks over the court, ignores instructions, and escalates conflict, it sends a clear message: this person is difficult to manage,